Dear learners, so far I think they have completed all theory papers counseling session. Today onwards, I think the project related sessions today and tomorrow. By tomorrow, we are closing it. And so far, recorded videos have already uploaded in our RC Visakhapatnam YouTube channel. And I request all the learners, please make use the opportunity, because tomorrow we are going to wind up these counseling sessions. If you have any theoretical related or other content related or any other subject related doubts, you can have the interaction with your faculty, academic counselors. Both are available. It is a good opportunity where Mr. Prasad is available. At the same time, Ms. Usha also available. You can make use of the facility and gain the more knowledge to write your examination and related to your subject. Thank you. Madam, please go ahead.
Yes, thank you, sir. Okay. Good evening, everyone. I hope every students are joined already. So today in this class, we are going to cover a little bit portion regarding the like our course structure. Though we already completed all the major important portions, what the lecture like the through that lecture series that we are going to cover regarding what is patent, what is IPR, and what are the classifications, how to file, what are the practical aspects, and what are the legal challenges also we have. All the areas we are already covered. So, as today's schedule has already been scheduled only for the practical work, to giving you a instruction about how to make that practical task for you all, the assignment you need to submit. But I would like to before telling you about directly enter into the project work, I would give you an insights about what are the like legal landscape we having for the evolution of our patent laws. Okay, so we are going to discuss on the first half of this lecture with the major landmark cases, and the second part we are going to discuss about the project initials, that what you have to do regarding your project task. Okay, so we are going to majorly discuss about the landmark cases is regarding only to the patent. So what are the cases in India has already been registered and having its importance being as a sources of law over there, that is which plays a crucial role for development of the protection of IPRs, like IPR rights, specifically in light of the patent Act or patent protection rights. Okay. So the first landmark case is regarding Indian cases where patent were granted. So we explain few of the listed cases only to the landmark cases I'm discussing today about their major facts, like, and also what is the basic issue was involved in that particular case, and later on that like what was the judgment has been passed by the said court, and how this judgment having its importance with our relevant topic or this course or curriculum. Okay, so the first and the most landmark case, we say that where the our patent has been granted through that application. The first case is regarding Vishwanath Prasad Radhesham. If you see that case law, like the full citation of that case law is Vishwanath Prasad Radhesham versus Hindustan Metal Industries. I hope you all are aware of these two industries, that basically you will see the day-to-day so many products they are being like making and selling in the industry, and specifically based on the kitchenware. Okay, kitchen like kitchen utensils and all everything will be included for their they are basically manufacturing those things, right? So here the questions is related how this to like in this like the person with this industry has get evolved with an issue. So here in this particular landmark case, we can see the major, fact we can say that the is arise between these two parties, where the inventor, Bishwanath Prasad Radhesham, who developed a new method for manufacturing the utensils. Okay, that was like claimed to be the more efficient than the existing method. Like whatever the common utensils we are being using we on instead of that they are making in a unique way, that way how they will produce a more better benefited utensils. So what happened in this case, that after getting its innovation, completing that whole idea of this invention, the inventor is going to file that an application regarding for the protection. But later on, it will be seen that those kind of utensils are already being used or packed, manufactured, and sold by those by the I'm sorry, that Hindustan Metal Industries. But here the question is come that what whether this inventor inventor's method for manufacturing the utensils having its or made with the met with the inventive steps or not. Like inventive steps is mentioning here means what are the unique mechanism and how it will be different or how it will be more efficient than the existing method for manufacturing those utensils are already being there, right? So after that it will be seeing that this method which is produced by this inventor, this method involved in a unique process which improves the durability and finishing of that every kitchenware. Like it will give it as a aesthetic look or maybe in a stylish product, in such a way it will be provided. So in that way also it become the unique in nature. So, so basically that this case is arose like when the patent validity was challenged on the ground that it was only on a minor modification of the known techniques. Okay. So after later on, the major legal point was the or the issue has been raised in this case that was this invention was truly new or just a small modification of existing technology can lead to grant a new patent. Okay. So in that question of law, when the court has examining and also all the by seeing all the contentions, the Supreme Court of India finally in the year of 1982 has passing the landmark judgment regarding that it was a genuine improvement regarding the by producing the you know that methods how it will be becoming its unique features. Okay, so based on that only the Supreme Court of India giving the permission for to it was not a violation of any somebody existed patented rights or not violating the patents of that the objection has been raised by the opponent. So because of that the Supreme Court allowing this patent application and giving to instructed the office to passing the patent to them. So basically, it was not an infringement. Okay. So because of that, Mr. Like in the inventor got the patent, patent in his name. So basically, this case is very much important for like we can say that the in early cases like where the Supreme Court is first time is explaining that how novelty and the inventive steps make an invention patentable. Okay. So after that, the another most landmark case law I will like to discuss here that is related to like Incon Limited, which is like this is also an Indian-based company. and like Encon India Limited versus Alois Webben. So in this particular case, Mr. like Aloy Webben, who was a German inventor, was created and created an innovative wind turbine technology. Okay, so later on, like Encon in India claimed that right based on the collaboration agreement with the same with the German inventors vote. Okay, so regarding this dispute has been the case has been filed before the Supreme Court by challenging this dispute, focusing on that Webben's original invention could be patented in India and parallelly who had the entitlement of the royalties as well. Later on, we can see that the Indian court had to first examine like regarding both the technicality and also for that innovation and regarding the originality of the ownership of agreement, what will be there. So the major issue has been raised in this case was who had the right to the patent and whether they are valid or not. So, in this question of law, by solving that issue, the Supreme Court of India uphold the Ajay Webel's, Alois Webben's patent, like the German inventor's patent, and um, giving the major importance to by protecting the foreign inventors' rights in India. And it shows that the India represents to the global protection of the intellectual property. If you go through with the third landmark case laws regarding F. Hoffman versus Cipla Limited. So basically, this case was filed before the PCT, and through that particular in this particular application of this complaint regarding in this case, the major fact was Roche held a patent for the built like a it is a Erlotinib is a basically an cancer treatment drug. Okay, but later on, Cipla launched a cheaper generic version of generic version of it in India. That same medicine. So later on, the patients group argued that that Cipla's product will be much more affordable medicine, and it was crucial for the public health. So the case was involved balancing the patent, like the patent protection for Roche, like with the public access to life-saving drugs. The major issue was raised in this question was that should Cipla be stopped from selling it or not? So resolving this issue, the judgment has been raised by uh, the learned judges regarding that the court has stated that Roche's patent is valid but refused to stop Cipla because cancer patients' right to affordable medicine was important that time. So it is basically by like the intent behind of this passing this judgment was basically it is important to balance the patent right and also versus the public health as well. The another most landmark judgment we can see over there that regarding um, Chemutara Corporation versus Union of India. This case has been filed before like the court regarding basically it is a case related to a patent on special chemical used in a plastics like which is get again challenged. So in this case, uh, Chemotara had patented the chemical used in the medical plastics. So like using in the making of a plastics. So, claiming the unique compositions that improve product quality, and also this patent was challenged by the competitors by arguing it was a obvious form of a prior knowledge. Um, because of that, the court examined like whether the innovation involved scientific inventive steps or not. So regarding this fact only, the major key landmark issue has been raised regarding was it really new or it's just obvious like whatever the basic components are being using for the making the plastics. Okay. So, on the outcome, if we want to say that the outcome of this judgment that the patent was basically upheld, and the major importance of this case law is through this case law only it is confirmed that the strong scientific patents are protected in India only. The another insights we can see through the landmark case of Mark Sharp and Dom Corporation versus Genmark Pharmaceuticals. This is a case in the like a case regarding a patent on a diabetes drug. So, um, like Mark developed first this sitagliptin. This is the medicine's name, which is a novel diabetic treatment drug. The German began manufacturing the same similar version, but without the consent. Okay, so in this, the dispute was centered on whether Mark's development was a like genuine scientific breakthrough or an obvious variant. The patent's enforceability was crucial for the protection of pharma innovations, right? So, because of that, the major issue has been raised in this case that is Mark's drug was genuinely innovative, or it is same like obvious whatever the already existed components are there like to making such drug. Then Delhi High Court was granting the landmark judgment in the year of 2015 by stating that the Mark's drug was novel and the like Jelenmark was this the pharmaceutical company who was again remaking the product. It was infringing. So that's why they are giving the patent to the real inventor. The major importance in this case was it providing a strong message for to win for a pharma patents in India regarding the pharmaceutical industry. Like after that, the landmark case regarding the landmark case of Agriboard International LLC versus Deputy Controller of Patent. So in this case, Agrobot applied for a patent on eco-friendly building panel model from the recycled materials. So the innovation claimed to reduce construction waste and also improve the insolution. The controller initially questions regarding the novelty and industry applicability before granting this patent. So by providing this this particular the issue was raised in this particular case that are this patent were valid and enforceable or not. So through this case, the in 2015, the court has been decided that Eriscon's patents was upheld, and the first big telecom standard essential patents case was registered in India and passed the landmark verdict regarding that. Then another landmark case regarding it is a case basically where that case was cited by the like you can see the official websites of IPAB where you can get through the details of this case, which is regarding Allergan Incorporation versus Controller of Patent. During the time of 2008, this was the case was decided or the coming before that authority regarding the facts, important facts regarding that Allergan applied for a patent for an eye drop formula instead of treating to the um, glaucoma. But the initial application was rejected, and which was claimed that it was only a minor modification of an existing formulation. But the inventor argued that the formulation increased drug, which is like stability and effectiveness, making it genuinely like innovative. So that's why they are being giving the proposal for to getting the permission for patent. So the the regarding that the major issue was raised in this case, that was it innovative or just a small variation by making that same component of the eye drop formulation. So later on, when this application was got rejected through the like that application from the patent office, then the applicant that Allergan applied for a patent for the applied for an appeal for this particular against that rejection of that particular patent application, and was regarding on the major issue was raised that was it innovative or just a small variation. So this appeal body for initially allowed it and allowed it this application and giving the grant of the patent license to them. And the major important area for this case is important because it's covering the area of like encourage pharmaceutical and also the research and development patents in India. Another landmark case we are saying, I would like to cite here, that is Alois Weben versus Yogesh Mehra's case, where like a long fight over wind turbine patent between the German inventor Weben and the Indian partners was going on. So regarding that fact itself, the major question of law has been raised by highlighting the issue that who was the rightful owner and where the patent was valid. So in this case, the Supreme Court in the year of 2014 uphold the upheld the Weben's patents rights, and it is being stating that it is very much crucial to strengthen the patent enforcement in renewable energy industry. So that's why they are granting the patent. So later on, another landmark case where the patent was granted, that is the one more very famous case regarding Nokia Corporation versus Rajesh Bansal's case. So this case was filed in 2009, which is dealing with the basically the uh, like Nokia held several patents, like they having different patents related to mobile phones. So including this, they are getting this patented rights through including the designs, communication technologies, and later on we can see that the Rajesh Bansal was allegedly copying the same Nokia's patented technologies in his products. So, because of that, simply Nokia filed a suit to stop the infringement and protect their proprietary technology rights in India. So, the major landmark, the major issue was raised in this landmark case was whether Nokia's patent was enforceable or not. So, by to resolving this issue, Supreme Court, the court has been held that the court initially passing an injunction order in Nokia's favor. So, this was become very important case law in the patent regime because it reinformed sorry, it is like reinforce the mobile technology again in the patent enforcement India. So these are the basic landmark cases where the Supreme Court of India has given its major landmark like the judgments which are very much crucial, and where we can see all the patents are application has been accepted and granted properly, though they have been facing a minor of complications as well. Now, we are going to discuss about some landmark Indian cases where the patents were refused, or those patents are basically not patentable. So, the first landmark case here regarding in the year of 2013, Supreme Court of India giving a landmark verdict on the case of Novartis AG versus Supreme Union of India. So the major fact of this case was Novartis wanted a patent for an improved form of cancer drug, which is known as Gleevec. But the when the Novartis applied for a patent for Gleevec, an improved version of the older same cancer drug, the company only claiming by stating that the minor chemical changes made it more effective. So the opponent, so on the other hand, the opponent argued this was not a unique one because it was basically an evergreening and not a true innovation. So because of that, public so on basically on demand of the public's health concern, these were significant. So because India relied on some affordable generic medicines. So the Supreme Court finding out the major issue in this case was, is it a new innovation or just a small modification of the same old drug or not? To resolving these questions of law, the Supreme Court of India basically initially rejected the application, and the court was stated it was an evergreening patent, which is already being restricted under Section 3D of the Indian Patent Act. So, because of that, their application for granting a patent was got rejected. The another landmark case we can cite here, that is regarding um, regarding uh, Diminoco AG versus Controller of Patents case. The major fact of this case was this the applicant was filed a patent for a process of producing vaccine, basically, which is using for live viruses. The patent office initially refused because living organisms themselves cannot be patented. And the case was clarified that where the organisms may not be patentable, not only that, but novel processes for using them, maybe it could be permitted. So the major question of law raised in this case, we can see, can a living organisms be patented or not? By answering this question, the Supreme Court has explained that like it was stating that this was the first case in India which is discussing the patentability of biotech inventions. So the judgment is based on that initially this application was refused, but later they will allowed it as a process patent in this case. Another landmark case we can see that Diamond Star Global Limited versus Joint Controller of Patents case. In this case, basically this case was related to that the applicant was filed for a patent on herbal medicine, which is derived from a traditional Indian knowledge. So the Indian Patent Office basically refused and stating that traditional knowledge cannot be patented to patented because to prevent the biopiracy. So these safeguarded the India's indigenous medicine heritage. So the major issue was raised that is traditional knowledge patentable or not, like in any form. So the judgment was passed by the court by stating that it is directly refused that by stating that it is already prohibited under section 3 under section 3 of this Indian Patent Act itself. And this case was very much important because it gave a protected India's traditional knowledge from the piracy cases. The another landmark cases where patent was not permitted, that is Yahoo Incorporation versus Controller of Patents case. So basically, Yahoo sought the patent for an email method, but email method regarding by email delivery and management system. So the patent office was refused by saying it was a business method which need to be implemented on a computer. So the case was clarified the limit of patenting software as such regarding the applicants. So the major landmark question of law has been raised in this case was is software or business method patentable or not? So the Supreme Court of India clearly by stating refusing this patent application made by Yahoo Corporation and by stating that it is directly protected, like restricted under Section 3K of the Indian Patent Act. So it is clarified no patent for business method or software patent will be granted by the Indian Patent Office or through our patent law regime. The another landmark case, if you can see that regarding Microsoft Corporation versus Assistant Controller of Patents. So in this case regarding the Microsoft was filed a patent for software technology basically. So which was run for the computer programs. And the patent office basically initially refused by citing that it is also being again restricted under section 3K of the Indian Patent Act, where it is being clearly stating that no software technology can be patented because it is run through with the codification of the particular task which is comes under the protection under the Copyright Act. So it will not be get protected. So this case was reinforced that pure software can only this is stating that only on pure software that be patented in India, but unless it produce a technical effect. So the landmark issue was highlighted over here that is a computer program patentable or not? So the based on the application filed by Microsoft Corporation, the application was refused by the Supreme Court of India, and it was stating that it is a clear restriction mentioned under Section 3K of the Indian Patent Act cited already. So the importance of this case is this case was reinforced the limitation on the using of the software patents for granting a new patent or innovation in the namesake of innovation. Another landmark case was Eber Spear case, which is basically they are basically file an application for regarding a car air conditioning system. Okay, and which was challenged by the controller of patents later on. So the office argued that the design was obvious to someone who have been already skilled in this field, but the refusal made by the controller of patent, which emphasizes the requirement of non-obviousness in the patentability. So the question of law raised in this case was, it a new invention, or it is maybe a general or obvious type of invention. So in this case also the application got refused by the court, and as obvious, and it is explained that the major important was it was basically obviously staged for the invention which not met already. So that's why it's got rejected. Another case was cited by here that Ms. J. Mitra and Corporation versus Controller of Patents case, where the patent was filed for a medical diagnostic kits. Regarding that, the issue has been raised. Our method of diagnosis, any kind of diagnosis of a diseases, will be patentable or not? So, same to answering this question, the Court has been basically rejected the application, and it was being refusing by stating the ground was mentioned under section 3 subsection 1, subsection 1I, where it is being stating that it won't be permissible. So the importance of this case here that any kind of medical diagnostic methods are not patentable in India. The apart from that, the another landmark case was there in Frederick Alani versus Union of India's case. This was a case filed during the time of 2018 verdict actually, where a patent for internet what we can say that uh, kiosk like of basically it is a kind of a business model. Okay, so that patent was filed regarding that business model, how they will be conducted, through how, like what are the procedure will be there, how they will approach, the whole framework was regarding that the application was filed and got rejected by the office. So later on, this application was go before to the authority to citing the citing this issue, major issue regarding is this software or any kind of business method was patentable or not. So same as it's already been get restricted under section 3K. So court the board is also being refused and like initially the board IPAB was refused that application and on the ground of section 3 subsection K. But later the Delhi High Court said that computer programmable technical effects may be patentable depending upon the utility. So the major importance of this case here, this case has opened a debate on the take effect based software patents regarding regime. Okay. The another landmark case, one more landmark case was there, which is related to like Hindustan Lever Limited versus Controller of Patent. So this landmark case was cited by the Supreme Court of India in the 2007, where the major the problem was raised regarding that the patent for a new soap like a soap formula, which is been like the issue question of law has been raised in this case was uh, is is it really new or just the same thing other soaps are already being produced in such a way that can soap formula will be get protected or not. So initially the court was rejected that application and by saying that by saying stating that it is very much important to note here that merely only any cosmetic changes composition of making of any type of cosmetic changes by making of any new product, it does not deserve any kind of patent because it's a common and already being existed knowledge will be there. And the last case I would like to cite here that Lupin Limited versus Controller of Patents case in 2015. The Supreme Court of India, who was cited here in this case, that majorly Lupin applied for patent for a salt of an existing drug, in this case, basically, Lupin applied for a patent for a salt. Lupin applied for patent for a salt from of an existing drug, which is already being somebody is already being getting the permission. The office refuses basically to granting a new license for this particular the new drug, because it is being already being restricted directly under section 3D, which considering it a major basically a not to covering a major problems, rather it is just a minor variations, right? So because of that, this case was simply stating the area that this strengthen India's strains against the evergreening by pharmaceutical companies, and the question of law has been raised in this case that is it is a new drug or just a new form of a known drug. So basically, as it is being already being restricted under Section 3D, so that's why the Supreme Court of India is refused the application for appeal and reinforce the Indian stance against the evergreening of pharmaceutical patents. So these are the, like we will say, the highlighted and interesting landmark cases where the both the insights we are already being discussed, that in what circumstances of the cases the Supreme Court of India is already been giving the permission, and in what are the cases will be there and what reason the Supreme Court is already rejecting the applications. So I would like to discuss one more case here, that is related to Garware Walls Ropes Limited versus AI Chopra and another. Basically, this was a case which initiated before the Bombay High Court, that is the Nagpur branch. Okay, Nagpur bench who was decided this case on 19th of December 2007. And with the quorum of, if we can say that A.A. Joshi, the justice was there, with his quorum only, the case was cited. So it was basically an appeal was filed later on before the Supreme Court of India, which is again decided on 1st August 2008. So basically, in this case, the Garware Walls Ropes Limited uh, held two patents. Basically, the first patent, which is related to the steelware rope net system, and another patent was spiral lock system. So the company basically alleged the respondent number one here was AI Chopra. So the basically here the major issue was uh, this in this case, whether the Garware established a prima facie case on the patent infringement or not. Through this case, this issue only, the Bombay High Court cited initially that the serious trial issued existed based on the prior use and the government use. So the rule that was questioned could not be conclusively determined at the interlocutory stage. So basically, this application was refused to grant a temporary injunction. And same for the Supreme Court of India also. Garware appealed to the Supreme Court when then the Supreme Court set aside the Bombay High Court's judgment only, and remitted the matter back to the High Court again for same consideration of it. So basically, the High Court initially refused the injunction due to complex factual issues. And later on, the Supreme Court also emphasized that the prior use and Section 100 defense must be carefully examined and send the case back to the fresh disposal only. So these are the insight on the first half we are going to discuss. The second half part will be service takeover.
Yes, thank you, ma'am. Uh, Hello, students. I'm the Prashant Prasad. I'll be dealing with this project handling entirely. So far, I think you have gone with all these lectures, and you are much aware of what is patentable and what is not patentable. So you'll better come to a conclusion what is an invention, the major key factors involved in patenting, and what inventions are patentable and what are not patentable. So we'll come up with this project handling thing. Coming to the aspect of project work, the thing is that you have to first go with the synopsis, proposal. You have to make sure that the proposal is ready, and that too I think by November you should submit the uh, project work. In order to submit, firstly you have to make sure the proposal to be ready, and it should be duly accepted by your supervisor. Moreover, either me or Ramanamurthy sir will be the supervisor for you. And proposal to be made in two copies. The proposal should contain at least 400 to 500 words, and your project will be consisting of should consist at least 4,000. Proposal is 400 to 500 words, and project is in between 4,000 to 5,000 words. And the project is even to be made in two copies. One copy should be sent to the university, where the address is I think books are available with you guys. Course materials are available with you. Anyone?
I had opted, sir, for online study material
Okay.
myself.
Handbooks are provided. Any handbooks are provided.
No,
Not yet. Okay. Then the thing is that that some annexure formats were there, and what are even what you need to how you need to, that was clearly mentioned. Even for some flowcharts which will give you a brief idea what is the timeline procedure for patent filing and all. You can see in the handbooks, and even I can provide you some PPTs which are available with me also. Moreover, I'll be the person guiding you in project handling entirely. And first and foremost thing is the proposal should be ready. You should work on two aspects, whichever you within the entire coursework. Whatever the topics you like the most, which you are interested in, just choose two topics, any two topics. Either it should be this thing, drafting and filing a provisional patent application, or opposing a patent application. Take some two case laws, whichever you feel interesting. Whichever you feel interesting, take one case law and one aspect, to be two components you should uh, include in your project work. Two components should be covered. Within the two components, one should be I suggest one should be drafting and filing a provisional patent application, or complete specification, along with complete specifications, or something you can oppose a patent application, or defend a patent granted on grounds of prior art. those things like caseless will be available. So much, so many caseless will be available in the internet. You can go through whichever you feel interesting. Just go through and just you make it like some own like if you go through a case law, something interesting question might come up with in your mind. You just come up with that idea and like you just make an application like in defending that granted patent or something like that. You can do like that. So two components should be covered. uh, anything whichever you like, that should be within the coursework. That's it. And the two components like it should be in a single side only. The page should be single sided, and as two copies are required, it is suggestible that go for a like word like draft, like typing one. Don't go in handwritten. Even handwritten is also suggestible, but like as two copies are required, it will be difficult for you. So better like go with an better go with this like typed soft copy only, like soft copy. Later you can convert it in PDF and then like you can take a print of it. So it will give you even like better. It will be much impressive. It will be much impressive. So it is suggestible. First and foremost, like you should be ready with the topics, any two topics, and then like synopsis needs to be prepared. The synopsis should cover like the objectives, like in like what are your research objectives, like what do you want to explain briefly, the reason like for selecting the topic, like, that should be content. And the introduction part should be there, and the research methodology like which you are adopting, that I'll guide you, like that I'll guide you in due course of time. Like if you even like get in touch with me, like I can guide you. Just share me the synopsis, like, and I'll guide you in making a better draft of it. And the area of study, like uh, area of study in the sense like on which basis like your project is in, on which basis your project is in, and the analysis of data like you are being collecting, like those needs to be discussed in the synopsis. And then the conclusion, even you can add like research questions, the problems, those things like. But foremost, like these things should be covered: objective, introduction, methodology, area of study, and conclusion. Like these are the foremost things like that needs to be covered in your research proposal, and that should contain like 400 to 500 words. And even for that, like an annexure A is given in the handbook. Annexure A is given in the handbook, that I can even provide you. That needs your supervisor's assent. Then like attaching that, like you need to send the proposal to the university as well. But however, you don't need to wait for the approval from the university. You can start your work immediately, so that like if you are sitting for next Jan cycle, it will be like it will be covered in that, like your project which you are like submitting, the score will be given within that one. If you are delaying it like for the next cycle, it will be considered. That's what is the thing. And coming to the aspect of this project thing only, and even like the address, I'll just type my mail ID over here in the chat box. You can just mail me like directly, so that I'll provide you with the things like for further communications and providing. I provided my mail ID. Even some hand booklets and PPTs were like available for your understanding and reference. I'll provide you with that, and even this like address where the proposal needs to be sent and where the project needs to be sent, and even the annexes which need to be attached, and the supervisor signature is required in that annex. Along with that, like you need to send the proposal. After like finalizing with the proposal, you can work on your project work even. The project work also should be like in the like one-sided pace. It should be minimum 4,000 to 500 words, 5,000 words minimum. Like there is no bar like in the maximum limit. As two components are there, like even it can include like diagrams, like some some diagrams, even like pie charts. You can include them by making that. And even if some diagram you need to insert, like convert it into JPG format, like you can make it handwritten and you can convert it into like JPG and soft copy. Like later you can paste the same even that you are well aware of, I guess, so that it will be easier for you if only for the aspect of diagrams and all, to include that to include that in the project. And this is what like with regard to project thing in brief. Further, like further, like even I'll guide you. Like it should contain like this title page and nothing. Like you don't need to bind it like hard binding and all. Like soft or like plain paper, where ignore labeling and all will be there. Like those binding and stapling is fine, sufficient. Or ignore won't encourage like this plastic thing and all. Like you can just use the papers and you can bind them like uh, properly, and you can send the same. Or you can even like use thread knots also, like threading proper threading. And you should even like, as I stated, like you should make two copies. One copy needs to be sent to university like after completion of your project. The university will take time to evaluate, so that's why like one copy should be returned with you. And whatsoever you are couriering, make it through register post with the register post only, so that like the thing tracking things will be there with you. And minimum 40% of marks like is mandatory in like this project as well, like to pass the project. In case like if like 40% is not awarded, like the same information will be provided to you along with the evaluator's comments, and you need to redo the project like by basing on the light of comments provided by the evaluator. And then like only this annexure B is required, and again like annexure A, like this supervisor's assent is not required for like if you are redoing. Like moreover, that won't be the scenario. Like I'm just telling you for your idea. So that's what like was in brief about the project, like what you need to do. And like just see for the topics, like see for the topics, come up with the topics whichever like you are much interested in. I think you are well aware of like this bibliography, uh, these things, everyone. Ravinji, hello, hello.
Sir, you are audible.
Yes, yes. Like I'm asking, just like are you well aware of this bibliography and all, like, making like what?
We will revise the format in which case law is to be presented,
Not
the
like case
citation
law,
for the
like
case
just
law.
for references, like citations and all. Like you are well aware of like in which stream are you in? I don't know. That's what like was the concern. Uh, that's what like the citations and all like you can mention. Uh, where in bibliography like these citations can be mentioned, so that like it will be even much more impressive and there won't be any like concerns regarding the work also, like the work and authenticity of the data like that you are gathering. So this is the thing brief like about the project work. Like tomorrow even like we can come up more with like whatever doubts you are having till now what you have discussed, like whatever doubts you are having, like we can come up with a session for tomorrow, like freshly. If you're having any, yeah, tell me.
Sir, I have a doubt, one or two clarification as of now. Then today I will go through after this session in the e-copy of the project handbook, and in case of any further doubt tomorrow, I will
Yeah, that's
request.
okay.
One thing, sir, what is the qualification of the project supervisor? Means, can we take you as the project supervisor or how?
Yeah, like registered academic counselor will be the supervisor. Actually, like registered academic counselor, like they are taking like postgraduates only, like from this specialization. Like I'll be
Okay,
your project supervisor. Moreover, like I assisted like few people in the previous batches, or else like even Ramanmurthy sir also. But like Ramanmurthy sir is like specialized in another area, like another subject. I was like I and me and Rusha sir also like we were specialized in IPR and cybersecurity.
means apart from the academic counselor, we can't
Like
take
it
outsiders.
will be like in your nearby region. Like if you are having any like from the place where you are, any region center is having like faculty like law faculty. You can even take them like as your supervisor.
Okay. Sir, secondly, these two components which we have to select. One is
Hmm.
either drafting, filing, final
Hmm.
specification, opposing a patent application. Now that has to be
Huh.
the same like subject matter, or drafting can be different subject matter. It can be in and opposing can be a different subject matter. And can it be
Huh.
hypothetical, or it has to be
Like it can be like it can be different. Like it shouldn't be the same like similar. Like as you are interested, like as you are interested you can take like the same things like both, but I suggest you to go with like different aspects, different components, because like the major like objective of the project is like you should be practically well aware of the things like patent filing, like these things like you should be practically well aware, so that like I suggest you with go with like different components.
sure, sir. Thank you so much, sir.
That's what it was like the objective of the thing. And any like any subject concern like the topic like specifically like in case like some point is missed in the in delivering the lecture still now.
Dear
So
learner, sir, 1 minute. Regarding
sorry.
the project allotment of the guide and other things, we will discuss tomorrow. We will tell we are having presently two approved academic counselors. As I think Mr. Prasad has told you, we are having another academic counselor also. Now, I think Ms. Usha also joined. after receiving the request letter from you with the signature and identity card, we will allot the guide, project guide, as per the convenient of their availability, and some more faculty also we will see the possibilities and we will allot the guides. There is no issue. You can make use this opportunity to ask the questions about your subject related matters. Anyhow, tomorrow we are going to complete the sessions. I will give you the other academic administrative related questions answer. Now you please concentrate on the content. Thank
Okay.
you.
Thank you, sir. So that's what in brief, like that's what even sir stated, like that you don't need to worry at all, like regarding the allotment of the guides and all. Like you just need to mail them. You just need to mail them, like basis on your request, like they will allot the things. And regarding the project, like this is a like these are the key points like which you need to know, like what are the criteria to be observed. Mm, mm, like thing is that like if you are just having a look regarding the like drafting of a patent document or like opposing a patent grant, if you're going through it, like you will come across, like you will come across the things like what needs to be included, like what the things to be like what are the requirements, like while drafting of a patent. If you are going through, like it needs like patent specification, like whether it may be like provisional or complete specification. Like if you are like drafting just a provisional specification, immediately like within like next 1 year, like complete specification needs to be like filed. And in provisional specification you don't need to mention like all the aspects, like all the aspects of the of your invention, like of your invention. However, in complete specification, if you are going like to file, the complete specification should contain like the title of invention, preamble, like prior art, drawbacks of the prior art, and then like what solutions you are coming up with, like, and then objectives, summary of the invention, statement of the invention, detailed description of the invention, and even like the claims, like whether it may be like the dependent claim or independent claim or omnibus claim. It can be, and it should must and should like it should contain these things and abstract even. Those things like need to be covered. And in like opposing the this thing, like opposing or defending a patent, if you're going with, you'll come across like with the things like whether it should be like it is a pre-grant opposition or post-grant opposition. Like if it is like pre-grant opposition, it can be like filed till the time like from the date of publication, like when initial publication will be given on the website, like with the website and all. From the publication till its grant, you can go with like pre-grant opposition and post-grant even. Like post-grant, It's like till the time of like 1 year of its grant of patent. Like you can give it post grant application. And what are the grounds for it? You're going through like even on different grounds, like just go through some case laws, which even ma'am discussed. Like for that only, like today, like we just come up with some case laws so that it will be much more interesting. We are just going through with some case laws. Like I suggest to go with like one case law is a like turmeric case. If you are typing, it's like traditional knowledge and patenting discussed in the first class itself. Just go with the turmeric case from Google. Like it is landmark ruling in 1997 by USPT. Like if you're going with like you'll just get to know like what is the thing that can be patentable, and you'll come across like with like number of doubts, like whether like what is novelty, how it is important, like, and traditional knowledge can be considered like for patenting and what. So that's what I'll suggest. If you are like having any concerns regarding any topic, like any topic which we have skipped or something like that, like we'll come up with, like if you can just let me know, like tomorrow I'll just come up with those things. And even ma'am is also available, like we are there to help you out. And regarding project also, like if you're having any doubts, like what needs to be like what area like should we choose, if you're having any doubt regarding that also, like we are much uh, here to help you out, like much helpful. Yeah, yeah. So make utilize of the time, like so that like we'll be prepared, and tomorrow like we'll come up with the things. To the most, like I think ma'am has covered the things. And regarding project also, in brief, like I have explained you. If you're just like let me know like in brief what you need, so that like I'll come up. Even if you want some topic in depth, if you want something like to be explained, we will. Or else like we'll make a revision tomorrow, like I'll just go through once, and then like I'll even suggest like with you some topics. I'll suggest you with some topics. I thought like today we'll have some discussion on the things, like what needs to be included in the project. Okay, then like shall we wind up the session for today then? Like tomorrow, like you just go through once, like regarding the caseless and just come up with your doubts with the topics like which you choose already. And then like we can discuss further, and even like I'll just go through some PPTs, even like regarding with respect to some case laws, even like which will be much more interesting with you for you. Like I'll just explain in brief regarding like some case laws which will be much more interesting, and then like that areas like which you can pick. I'll just come up with those things. Like, if you have any doubts, like we can discuss, or else like tomorrow I'll come up with those things, and then like small revision kind of and brief about like patent act and how it is like useful, and like patent agent, what is the qualification, like infringement of patents, like in brief. Are you aware that e-filing of patent application is available? Like,
It's online filing, right, sir? No? E-filing,
uh-huh, uh-huh.
north, south, east, west. Yeah.
Yes, yes, yes. Yeah. Like given that like those things, like e-filing patent is available from, it is provided by IPO. Like regarding that PCT, like have you gone through PCT filing? What are the advantages like, and in order to minimize the like in order to minimize the thing like the expenditure, like you don't need to go through like each and every country and file the thing. Whatsoever the application which you file in PCT, like it will be applicable for the member countries, like entire member countries, and the same like what right like which you are getting, same will be applicable like in each of the country. And prior date thing, like you'll be getting like prior date, right, you'll be getting while using this PCT filing. It is like more economical and easier way to file patent as of now. Like the practice is concerned, like this is much more like easier way to go with. And for that, like even I don't know, like ma'am, and even if you are going through the recordings, like ma'am explained like this e-filing, like PCT and all, like this PCT also, like I had a PPT where I'll even share with you. If you're just going through, like you'll get a brief, like what is the procedure and all, like fee structure, like you need to go through the website, like latest fee structure and all, like what is the thing, and it will be much more like economical and convenient way, I suggest. So that's what in brief, like for today, like we'll and wind up the session like today, and tomorrow I'll come up with the areas like which you can work on the work on with your project, and I'll even just guide you in some with some case laws, like this is like suggestible and all, so we can discuss tomorrow. So can I wind up like with the session for today?
Thank you, sir. If it is completed, then okay.
Yes sir, like I thought like we can discuss much more, like if the doubts are coming up like
Okay,
tomorrow,
okay,
like
then
I,
no problem. Tomorrow, same time,
yeah,
maybe
yeah, yeah, I'll
tomorrow,
join. Like I'll be taking the things, sir. Like tomorrow, like I'll be taking it the area like which it is suggestible, and in brief, like with the some case laws and all, like the project thing, like I'll deal with along with
okay, sir.
some. Okay,
Okay,
sir.
thank you. Thank you very much.